If you're a senior gun owner, there's a good chance someone has already told you a lie that sounds legal. And if you believe that lie, you could give up rights you never actually lost. Quick question before we continue. Are you subscribed? Because this channel is built for people like you who want the truth before bad information costs them money, freedom, or both. If you want simple gun law updates without the fluff, hit that subscribe button right now. Let's get straight to it. A lot of older Americans think gun rights fade with age. They think turning 65, going on Social Security, getting help with bills, or moving into retirement life somehow puts them on a legal countdown clock. That fear is everywhere. And honestly, I get why. Laws are confusing. Rumors spread fast. And when one person at the gun counter says, "I heard seniors can't do that anymore," people panic. But here's what just happened when I dug into the law again. A lot of these so-called limits are not real. Some are half true, some are old rules that never even took effect, and some are just flat-out myths that keep seniors scared and silent. So in this video, I'm walking you through 7 forgotten senior gun rights no lawyer seems to mention. Not fantasy rights, not internet comment rights, real legal points you need to understand. And I'm going to explain them in plain English. First forgotten right. Federal law does not have an upper age limit for owning a gun. Let that sink in. There are minimum ages in federal law, but there is no federal rule that says you age out of the Second Amendment at 65, 70, or 80. Most people never hear that clearly. They hear age talk all the time, but it almost always focuses on younger buyers. Here's what matters for you. Under federal law, being old is not, by itself, a banned status. Age alone does not make you a prohibited person. In simple terms, that means the government does not get to say, "You're too old now, hand it over," just because you had another birthday. Now, this is where it gets interesting. Some seniors talk themselves out of buying, carrying, or even keeping a firearm because they assume the law sees them as a risk. But the legal question is not, are you over a certain age? The legal question is, are you in a category that actually bans possession? Those categories are things like certain felony convictions, certain domestic violence convictions, certain court orders, unlawful drug use, and certain mental health rulings. Old age is not on that list. Here's a real-world example. Imagine you're 74, you live alone. You want a firearm for home defense because break-ins have gone up in your area. Your neighbor tells you, "I'm pretty sure there's an age cap now." That sounds believable. It's also wrong under federal law. If you are otherwise lawful, your age alone does not erase your right. Second forgotten right, Social Security and Medicare do not automatically take your gun rights away. This one has scared seniors for years. Maybe you heard this at church, maybe at the range, maybe from a relative who said, once the government starts sending retirement money, they can flag you. That rumor has had 9 lives. But here's the truth. Getting Social Security or Medicare does not automatically put your name into the gun ban system. And here's the part nobody talks about. Years ago, there was a rule tied to certain Social Security disability situations that caused huge concern. A lot of people still repeat that story like it is active law today. But the rule people keep talking about was blocked before it ever took effect. So if someone tells you, don't apply for benefits or you'll lose your guns, stop right there and double check what they're saying. Have you ever noticed how bad legal myths never die? They just get passed from one worried person to the next. That's exactly what happened here. Seniors heard one scary headline and many assumed every retirement benefit came with a hidden gun penalty. It doesn't work that way. Now, I need to be careful here. State law and individual facts still matter. If someone is under a separate legal disability, that is a different issue. But simply receiving retirement-related government benefits is not some automatic off switch for your rights. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when an officer asks about your gun. Subscribe now so you don't miss it, because these small details are the ones that save people from big mistakes. Third forgotten right. Needing help with money does not automatically mean you lose your gun rights. This one shocks people. A lot of seniors think that if they need a family member to help manage bills, or if someone helps with paperwork, that alone proves they can't legally possess a firearm. That is not how federal law works. This is one of the most dangerous myths because it causes people to surrender rights out of fear, not law. Let me break this down for you. Federal law uses terms that sound intimidating. One of them is adjudicated as a mental defective. I know that phrase sounds harsh and old-fashioned. What matters is what it means. It does not mean a doctor thinks you're forgetful. It does not mean your daughter helps with the checking account. It does not mean you had a bad week and got confused. In general, federal law is looking for a formal legal determination by a court, board, commission, or other lawful authority, or for a qualifying commitment to a mental institution. That is very different from a rumor, a family opinion, or a basic medical diagnosis. Here's a hypothetical example to explain this. Let's say Robert is 79. He had a mild stroke. His son now helps pay the electric bill and organize medications. Robert hears from a friend, Well, if your son helps with finances, you're done. No more guns for you. That statement skips a huge legal step. Help with money, by itself, is not the same thing as a formal legal ruling that triggers a federal prohibition. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. And here's what most people get wrong. They mix up health concerns with legal disqualification. Those are not always the same thing. Should every person honestly assess safety? Of course, that matters. A lot. But safety choices and legal status are two different questions. Don't let somebody blur them together and scare you into giving up more than the law requires. Fourth forgotten right. If you are a veteran senior, a fiduciary issue has not always meant what people think it means. This is the part that shocked me, because so many older veterans were told some version of the same story for years. If the VA says you need help managing benefits, your gun rights are gone. That issue has been a huge point of anger and confusion. And in 2026, the VA announced it was ending automatic reporting to the federal background system based solely on fiduciary status. Why does that matter? Because needing help with benefits and being a danger are not automatically the same thing. A lot of veterans, especially older ones, felt like they were being treated as guilty without proper due process. That fear pushed many into silence. Some even avoided getting help they needed because they were worried about what it could trigger. But here's the crazy part. Many families still don't know the policy changed, so they keep giving advice based on yesterday's rules. If you are a veteran, or if you help one, this is the moment to stop assuming and start verifying. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who get these legal updates before the rumor mill twists them. Hit subscribe right now. Fifth forgotten right. You still have federal protection when traveling across state lines with a firearm, if you follow the rules exactly. This one matters a lot for seniors. Why? Because seniors travel. Road trips, RV trips, visiting kids, visiting grandkids, snowbird life, hunting trips, cross-country drives. And this is where people get nervous because one wrong turn can put you in a state with laws very different from your own. Here's the part nobody explains well. Federal law has what many people call a safe passage rule. In simple terms, if you can lawfully possess the firearm where you started and where you're going, federal law gives protection for transporting it through other places, but only if you meet strict conditions. And those conditions matter. The firearm needs to be unloaded. It must not be readily accessible from the passenger area. If your vehicle has no separate trunk, it should be in a locked container and not in the glove box or center console. Miss those details, and your "I thought I was legal" story may not help much. Imagine you're driving from one gun-friendly state to another. You stop for gas in a stricter state. Your handgun is loaded in the console because you thought federal travel law covered everything. That is exactly the kind of mistake that creates trouble. Most people think safe passage means total immunity. The truth is narrower. It protects travel under specific conditions, not sloppy travel, not maybe travel, specific travel. So yes, this is a right. But it is also a trap for the careless. Don't make this mistake. Before a trip, check the start state, the destination state, and the transport rules, especially if you carry medicine, luggage, and other gear that can make quick access questions messy. Sixth forgotten right. You can legally pass firearms to your heirs, and federal law has an inheritance exception that many families never hear about. This one is huge for seniors, and almost nobody talks about it until a funeral forces the issue. Now, let's say you have a collection. Maybe it's 2 hunting rifles. Maybe it's a safe full of family history. What happens when you want those firearms to go to your son, daughter, grandson, or another lawful heir? Most people think once state lines are involved, it's impossible. That is not the whole story. Federal law generally restricts direct interstate transfers between unlicensed people. But there is an important exception tied to inheritance, meaning bequest or intestate succession. In plain English, that means passing property through a will or through the legal process when there is no will. Why does this matter so much? Because families make bad panic decisions when they don't know this. Guns get dumped at pawn shops. Heirlooms get turned in. Relatives move them the wrong way. And all of it happens because nobody sat down and said, wait a minute, there's a legal path here. Here's a hypothetical example. A widow in Texas wants her late husband's rifle to go to her adult daughter in another state. The family assumes it must be illegal because they live in different states, but inheritance rules can change that analysis. The exact process still depends on the facts and on state law, but the big point is this: the law is not as hopeless as families are led to believe. And here's what most people get wrong. They wait too long, they do no paperwork, they leave no instructions. Then grieving family members try to figure out gun law in the worst moment possible. If you're older and you own firearms, part of protecting your rights is planning your transfer clearly and legally now, while you can. Seventh forgotten right. If you get wrongly delayed or denied during a gun purchase, you have the right to challenge it. This may be the most overlooked right in the whole video. A lot of seniors hear denied or delayed and assume that's the end. They think the system has spoken and there's nothing they can do. That is not true. If the background check system makes a mistake, there is an appeal process. Let me explain why this matters for seniors more than most people realize. Older Americans often have longer paper trails, more addresses, more records, more name mix-ups. Sometimes old cases were dismissed. Sometimes records were entered badly. Sometimes a person gets confused with somebody else who has a similar name. When that happens, people panic. They feel ashamed. They leave the store and never come back. But wait, there's something even more important. You can challenge the accuracy of the record. You can request the reason for the denial or delay. In some cases, fingerprints and court records help clear it up. That does not mean every denial is wrong, but it does mean you do not have to treat every denial like a final judgment from the sky. Here's a traffic stop style mindset that helps. Stay calm. Don't argue with the clerk. Don't make up facts. Don't assume the problem will fix itself. Start gathering documents. Find out what record was used. If your rights were restored, or if the system is relying on bad data, that matters. This information could literally expire the moment laws or policies change again. Subscribe now, because the next video explains the legal mistakes people make after a delay or denial, and how to avoid turning a paperwork problem into something much worse. So, what's the big takeaway here? If you are a senior gun owner, the law does not erase your rights just because you got older. Age alone is not the ban. Rumors are not the ban. Fear is not the ban. Specific legal facts are what matter. And that's why this video matters, because too many seniors give up rights they still have or make mistakes because nobody explained the law in plain English. If this helped you, subscribe right now and stay with this channel. I spend the time digging through this stuff so you can understand it before it affects your life. One last simple disclaimer. Laws can change and state rules can be very different from federal rules. So use this video as education, not personal legal advice, and talk to a qualified attorney if your situation is specific or urgent.